Okay, let's unpack this. When most people hear the phrase the Fifth Amendment, I think their mind immediately jumps to a witness on a stand.
Oh, absolutely. Pleading the Fifth. That's the classic image.
Exactly, and the conversation usually just ends right there. But if you open up the actual text of that amendment, what you find is not just one simple right. It's like a super bundle of foundational protection.
That's a perfect way to describe it. It governs the entire relationship between the government and the individual.
It touches everything from police interrogations to the boundaries of private property ownership. It's truly one of the densest but most crucial pieces of our constitutional architecture.
And for you, the listener, really digging into the Fifth Amendment is, I think, a shortcut to grasping the whole philosophy of the Bill of Rights.
Which is what, fundamentally?
It's about drawing a line. It's about figuring out where necessary state power ends and where our individual liberty becomes irreducible. So today, we're really on a mission to translate these high-level legal theories into practical knowledge.
Right. Knowledge about fundamental rights that shape your daily life and your interactions with authority.
Exactly.
That is the mission. And since this deep dive is all about giving you the comprehensive view, we should probably lay out the four main pillars inside this single amendment.
We should. They often operate independently, but they're all linked by this overarching theme of restraining the state.
Okay, so what are they?
Right. So first, you have the protection against being prosecuted for the same offense twice. That's double jeopardy.
So finality.
All about finality. Second is the famous one, the protection against being forced to testify against yourself. The privilege against self-incrimination.
I plead the Fifth.
That's the one. Third is the broad, and I mean really essential, guarantee of fundamental fairness, which is due process. And fourth, the protection of your private property from government seizure. That's the takings clause.
That is a massive amount of ground to cover. But the way these rights reinforce each other, that's what's fascinating. Let's start with due process, because it really feels like it sets the foundational standard of fairness for everything else.
I think that's the right place to start. Due process it's the essential promise of fairness. It's the rule book the government has to follow when it acts against you.
And there's an important distinction right at the start, isn't there, between the federal government and the states?
There is. So the clause in the Fifth Amendment specifically limits the federal government. But, and this is key, the 14th Amendment has its own due process clause that applies to the states.
So in practice, the same principle applies pretty much across the board.
Exactly. The Supreme Court has interpreted them to be nearly identical.
So the core idea is that before the government, whether it's federal or state, can take away your life, your liberty, or your property, it has to give you fairness. It has to give you notice and a real chance to be heard.
Precisely. It's the procedural minimum. It prevents arbitrary government action. If the government decides to, say, levy a fine or revoke your professional license.
Which is a form of property or liberty.
It is. You are constitutionally entitled to notice of that action and a fair way to defend yourself. It makes sure that even when the government has a valid goal, it has to use fair procedures to get there.
So, given how fundamental this is, who exactly is covered? Are we just talking about U.S. citizens?
No, and this is the key insight from our source material. The scope is incredibly broad. The Fifth Amendment's Due Process Clause protects all persons within U.S. territory and jurisdiction.
All persons. So that means...
It means citizens seeking to come back into the U.S. It means corporations. They have due process rights too. And it even includes aliens, non-citizens who are inside the country.
So basically, everyone operating inside the United States gets this safety net of fairness. Are there any exceptions, any groups where this is limited?
There is a notable but very specific exception. It has to do with national security and military jurisdiction. The exception is for enemy alien belligerents who are tried by military tribunals outside of U.S. territory. In that kind of context, the Supreme Court has generally given the executive and military branches much broader latitude.
So if you're outside the U.S. in an active military conflict, you might not get the full set of constitutional rights.
That's right. But that is a very specific security-focused exception. The baseline rule for just about all activity inside the country is that everyone is covered by the due process guarantee.
All right, let's jump into that first major protection, double jeopardy. I think for anyone who watches courtroom dramas, this just means you can't be tried twice for the same crime. Simple, right?
It seems simple on the surface, but the legal reality, it involved these incredibly subtle, highly technical distinctions. especially when a case ends before a jury actually reaches a verdict.
The core idea, though, is finality.
It is. It's a profound idea. When the government brings the entire weight of the state against you, it gets one shot.
Yeah.
And once it's had its full chance to prosecute and it has lost, it can't just keep harassing you with more trials because it didn't like the result.
And this protection is at its absolute strongest when there's an acquittal.
Most absolute. And this is where it gets really interesting and kind of counterintuitive. Our sources confirm a basic truth. When a trial judge acquits a defendant, that action is final. It's just as final as if a jury had said, not guilty.
And there is zero possibility of a retrial for that same offense.
Zero. And here's the staggering part, which really shows you how much the Constitution values finality over even accuracy. This finality holds even if the judge made a clear, obvious, catastrophic mistake of law.
Wait, really? Even if the judge was just flat out wrong?
Yes. The key case here is Fong Fu v. United States.
So what happened in Fong Fu? What does that mean for the government?
In that case, the trial judge told the jury to acquit the defendants. And the Supreme Court later admitted that the judge's reason for doing it was based on an egregiously erroneous foundation.
So the judge messed up the legal standard.
Big time. And yet, the Supreme Court said that judgment of acquittal was final. It could not be reviewed. It could not be overturned. The constitutional right against being repeatedly harassed by the government is more important than correcting a judicial error.
That is a profound check on government power. It doesn't matter why the judge let the defendant go, only that they did so based on the merits of the case.
Once that judicial machine stops in the defendant's favor, it's over. But, and this is a huge but, the entire protection hinges on a label.
That labor?
We have to ask, was the judge's ruling really an acquittal or was it just a dismissal?
What's the difference legally?
The protection depends on whether the ruling, no matter what the judge called it, actually represents a resolution of some or all of the factual elements of the offense charged.
So an acquittal means the government failed to prove the facts of the crime.
Exactly. A dismissal, on the other hand, usually means the case was thrown out because of some procedural problem that has nothing to do with whether the defendant is guilty or innocent.
Okay, so let's contrast those. If a judge dismisses a case because the police, say, got evidence improperly, a Fourth Amendment violation, that's procedural.
That's procedural. In that case, the dismissal isn't based on the underlying facts. So the prosecution might be able to fix the error, get new, clean evidence, and refile the charges. They can often appeal a dismissal.
But not an acquittal.
Never an acquittal. Consider this other case, United States v. Martin Lennon Supply Co. You had a deadlocked jury. They couldn't agree. So the judge discharged them. Then the judge looked at all the government's evidence and decided, you know what? The prosecution just failed to prove the basic facts of the offense, and he granted a judgment of acquittal.
And since that ruling was about the factual failure of the government's case?
It counts as an acquittal. And the double jeopardy clause completely bars any appeal by the government in that situation. They had their shot, they presented their evidence, and they failed. Case closed.
Okay, now what about the other way around? A defendant is convicted, they appeal, and they win. The conviction gets reversed. Are they automatically free under double jeopardy?
No, absolutely not. And this is another one of those nuanced areas that often surprises people. If a higher court reverses a conviction because of a correctable legal error, let's say the trial judge let in some improper evidence, like inflammatory hearsay.
Or gave the jury bad instructions.
Exactly. Reprosecution is usually allowed. The government gets another chance to try the case cleanly, this time without the error.
So the defendant gets a new fair trial because the first one was flawed.
Right. But there was a massive constitutional exception. It was established in Burks v. United States.
And what's the exception?
If the reviewing court reverses the conviction because of total evidentiary insufficiency, meaning the prosecution just failed to gather enough evidence to convict in the first place, even before you consider any errors.
Ah, so they just didn't have the goods.
They didn't have the goods. In that situation, retrial is barred. That failure to prove the crime is treated just like a judge's acquittal. It's final.
That's a powerful line in the sand. If the prosecution botched their case and couldn't meet the burden of proof, they lose for good. If the judge made a technical mistake, the defendant has to face another trial.
That's the dividing line. And this protection extends even further. It's not just about retrying the whole crime. It also includes something called collateral estoppel.
That sounds technical. How should we understand that?
Lawyers call it issue preclusion. Think of it this way. It prevents the government from relitigating a specific factual issue, that a jury has already decided in the defendant's favor.
So they can't get a do-over on one specific fact.
Precisely. And this is where the story of the poker game robbery comes in. The case is Ash v. Swenson, and it just beautifully illustrates this protection.
Okay, walk us through it.
The facts are really clear. Several men robbed 6 different players during a poker game. The police arrest a guy named Ash, and they charge him with robbing just one of the players.
Okay, just one of the 6.
Right. At that first trial, the defense basically argued you haven't proven it was him. They raised doubt that Ash was one of the robbers, and the jury acquitted him.
So the key factual dispute was his identity.
It was the only real dispute. But the government, they were determined to get a conviction, so they immediately turned around and charged Ash with robbing a second player from that same game.
Even though a jury had already said he wasn't there.
Exactly, and the Supreme Court stepped in. They said you can't do that. The court applied what it called realism and rationality. They looked at the record of the first trial to see what the jury actually decided.
Not just the technical charge.
Right. And they determined that the only issue the first jury decided was whether Ash was present at the robbery. And that jury said no. So the government was precluded. It stopped from relitigating that exact same fact in a second trial. His involvement was a settled issue.
That's amazing. It forces the government to respect what the jury found to be true.
It does. Now, it's important to note the flip side. If the jury could have acquitted for other reasons, then relitigation can happen. But in the Ash case, the fact of his identity was the whole ballgame, and it was settled.
Let's shift now to the most recognized Fifth Amendment right, self-incrimination, the right to silence. For most people, this comes up through the famous Miranda warnings. The key question for all of us is, what triggers those protections, and what are the limits on what I can be forced to do or say?
The conversation has to start with Miranda v. Arizona. It came about because the Supreme Court recognized a basic reality. Police interrogation, in isolation, is inherently coercive.
Meaning the pressure to talk is just so intense that any confession might not really be voluntary.
That's the idea. The Fifth Amendment bars compelled testimony, so the court created a procedural shield to protect that right.
And that shield is the Miranda safeguards. Tell us exactly what prosecutors can't use.
Prosecutors can't use any statements that come from a custodial interrogation unless the suspect was first told their core rights.
The right to remain silent.
The warning that anything you say can and will be used against you, and the right to an attorney, even if you can't afford one. These warnings are what we call prophylactic safeguards.
Let's define prophylactic in this context. It's a bit of a technical term.
It just means they're preventative measures. You don't have a separate constitutional right to hear the warnings. What the court said, they are essential rules the police must follow to make sure the core constitutional right against self-incrimination is protected.
The big practical question for the average person is always, when am I actually in custody? I could be talking to a police officer, but when did the Miranda rules actually kick in?
Custody is defined pretty narrowly. It's when your freedom of action is curtailed to a degree associated with formal arrest.
So it's not about how tense the situation feels.
No, it's not about if the officer suspects you. It's about the real, legal, and physical reality of your freedom.
Let's run through some common situations that the court has said are not custody, because I think public expectation is different from the legal reality here.
For sure. A standard, ordinary traffic stop is not Miranda custody. You're temporarily detained, yes, but your freedom isn't curtailed like a formal arrest. You expect it to be brief.
What about going to the station on your own?
If you voluntarily go to the police station for questioning and the police make it clear you're free to leave at any time, that is not custody, even if you're the main suspect.
I remember the example of an IRS interview, too.
Right. Even an IRS interview in your own home usually isn't considered custodial. As long as the setting is familiar and you feel you can end the conversation and ask them to leave, it's outside the Miranda requirement.
But the second that freedom is taken away, the rules change, no matter where you are.
Absolutely. Questioning a person after arresting them in their own home? That's custody. Or, in another case, questioning a state prisoner about a totally unrelated federal tax crime. That was found to be custodial.
Even though they were already in prison.
Right, because for the purpose of that new interrogation, they were effectively arrested again. The pressure was significantly increased. It's all about the totality of the circumstances and whether the situation feels like a formal arrest.
Okay, so moving beyond when you talk, let's talk about what you're compelled to do. The privilege only applies to testimonial disclosures, right? Being forced to say something.
This is a huge distinction. The privilege does not protect you from non-testimonial acts. things that just provide physical evidence.
Like what?
The police can make you stand in a lineup. They can make you speak certain words for a voice identification. You can be required to model clothing or provide physical samples like handwriting, fingerprints, or blood.
The key is that these are evidence about your body, not statements from your mind that reveal guilt.
Exactly. The evidence is being taken from you, not extracted from your thoughts. This is also why refusing to take a blood alcohol test can be used as evidence against you. The test provides non-testimonial physical evidence.
But it gets tricky with documents, especially with the active production idea.
It does. So, if the government knows a document exists, like your tax records, they can usually compel you to produce it, even if the contents are incriminating.
But what if they're just on a fishing expedition? They don't know the documents exist.
Ah, that's the key. If the government is unaware of the existence or location of certain documents, then the very act of producing them communicates something testimonial.
It says, yes, these documents exist, I have them, and I believe they're authentic.
Precisely. And because that act is testimonial, the privilege can protect you from being forced to produce them. It's the implicit admission that gets shielded.
Now, let's talk about actually claiming the privilege. This is maybe the most critical takeaway for our listeners who aren't in custody. I think most people assume just being silent is enough.
And that is an immense danger. Generally, if you're not in a coercive custodial interrogation, you must explicitly claim the privilege to get its protection. Silence by itself can be ambiguous.
And this brings us right to that crucial case, Salinas v. Texas. It's a huge warning for anyone interacting with law enforcement when they're not under arrest.
The facts of Salinas are a perfect illustration. Salinas voluntarily went to the police station for questioning about a murder, a non-custodial setting. He answered questions for a while.
Okay.
Then the officer asked him a very specific, incriminating question about whether his shotgun would match shells found at the scene. And Salinas just fell silent. He looked down, clammed up, but he never said, "I'm asserting my Fifth Amendment right."
And at his trial, the prosecutor used that silence against him.
They did. The prosecutor argued to the jury that his sudden silence showed he was guilty, and the Supreme Court said that was okay.
Why?
Because in that voluntary, non-custodial setting, his silence was legally ambiguous. Was he just thinking? Was he surprised? Or was he invoking a right? Since he failed to speak up and claim the privilege, the silence was just treated as behavior which a jury was free to interpret.
So you have to say the magic words. You have to affirmatively activate the protection.
You do. Now, what if the government absolutely needs your testimony to crack a big conspiracy or something?
That's where immunity comes in. The government can force you to talk by giving you use immunity.
Correct. Use immunity works because it removes the danger of incrimination. It's a guarantee that your compelled testimony and any evidence derived directly from it cannot be used against you in a later criminal trial.
So they can still prosecute you for the crime, but they have to use evidence they found completely independently. Your forced statement basically vanishes from their case file.
That separation is what makes it constitutional. The compulsion is still there, but the harm, using your own words against you, has been neutralized.
And finally, let's talk about silence at the trial itself. If a defendant chooses not to take the stand,
that right is absolute. The prosecution or the judge cannot comment on that silence at all. The Supreme Court said any comment like that would be an unconstitutional penalty for exercising a constitutional privilege.
And likewise, if you get your Miranda warning and then stay silent, that silence can't be used to attack your testimony later if you decide to talk.
Right. That would be fundamentally unfair.
Yeah.
The government can't tell you you have a right to be silent and then punish you for using it.
All right, shifting gears pretty dramatically now. We're moving away from criminal procedure and into property rights. This is the takings clause, often called eminent domain.
Right. The clause says private property shall not be taken for public use without just compensation. This is the constitutional compromise between the government's immense power and an individual's right to their own assets.
This is a huge deal for anyone who owns a home, a business, any kind of land. The government can take your property, but it has to meet two conditions.
First, the taking has to be for a public use, and second, the owner has to be paid fairly for it.
Let's start with public use. How tight is that definition?
Historically, it's been incredibly broad. The courts give massive deference to whatever the legislature decides. Basically, the taking just have to be rationally related to a conceivable public purpose.
So as long as the government has a reason reducing blight, economic development, building a road, the courts will almost always say, okay, that's a public use.
That's the practical reality. The why is rarely the fight. The fight is almost always over the second condition, just compensation.
And what counts as property here? Is it just full ownership of a piece of land?
No, it's very expensive. Compensation is owed not just for outright ownership, what lawyers call a fee simple, but also for partial interests, like easements or leaseholds.
So if they only take part of your land, the compensation has to account for how that affects the value of what's left.
Yes, what's often called severance damages. And our sources gave us a great modern example of this with tax collection in Tyler v. Hennepin County.
Tell us about that.
It's a crucial clarification. The court confirmed that when the government seizes property to cover unpaid taxes, it can't keep any surplus money from the sale. If your tax bill was $50,000 and they sell your property for $100,000, that extra $50,000 is still your private property.
The government can't profit beyond what it's owed.
Exactly. It's protected by the takings clause.
Now we get to the core debate here. Physical takings versus regulatory takings. Let's start with the easier one. Physical takings.
A physical taking is any direct appropriation or a permanent physical invasion of your property. These are what we call categorical takings. They almost always require compensation.
What are some classic examples?
Permanent flooding of your land from a government dam project, or continuous low-altitude flights from a nearby airport that make your land totally unusable. If the government's activity results in a permanent physical encroachment, they have to pay.
And a more recent case showed that even a required temporary access can count.
Cedar Point Nursery. The Supreme Court said a California law that forced agricultural businesses to allow union organizers onto their property for a few hours a day was a physical taking.
Even though it was temporary.
Even though it was temporary and for a specific purpose. Forcing a physical presence, whether it's permanent or recurring, crosses that constitutional line.
Okay, so that sets up the much more complex counterpoint. Regulatory takings. This is when the government doesn't physically touch your land, but a new rule basically destroys its economic value.
And this is a much, much harder standard for a property owner to meet. Most regulations, zoning laws, safety codes don't require compensation. But the categorical rule for regulatory takings comes from a case called Lucas v. South Carolina Coastal Council.
What was the critical finding in Lucas?
The Supreme Court held that if a regulation denies a property owner all economically beneficial uses of their land, meaning it's left economically idle, worthless, that is automatically a taking that requires compensation.
So if you can't build on it, can't rent it, can't do anything financially productive with it because of a new rule, it's as if the government just took it.
That's the rule. The only exception is if the restriction was something that was already part of your state's property and nuisance law when you bought the land. For example, you never had a right to use your property in a way that creates a public nuisance.
And finally, there are those truly extraordinary circumstances, like war or a massive public disaster.
Right. In times of great public peril, property can be taken or destroyed without compensation. Think of the military destroying a building to prevent it from falling into enemy hands during a war. That's considered a sacrifice for the greater necessity, and the Constitution doesn't require payment.
Let's spend some time on something that feels connected to all of this, but operates by its own strange rules. Civil asset forfeiture. This is a highly controversial practice.
It is extremely controversial, and it's a profound legal anomaly. Civil asset forfeiture operates in rem.
That's Latin for against the thing.
Right. And that changes all the rules. The property itself, the car, the cash, the house, is the defendant, not the person who owns it.
So law enforcement is literally suing the money, not the person. What's the consequence of that?
The main consequence is that they can seize your assets based only on a suspicion of wrongdoing, without ever charging you with a crime. And because it's a civil case, the government's burden of proof is much lower.
Not beyond a reasonable doubt.
Not even close. Often it's just a preponderance of the evidence. Is it more likely than not that the property was involved in a crime? If so, they can keep it.
And the burden flips to the owner to prove their property is clean.
That is the astonishing procedural hurdle. You have to sue the government to get your own property back and prove a negative that it wasn't involved in criminal activity.
And this connects back to the right to silence in a really shocking way.
It does. A court can weigh your decision to use your Fifth Amendment right to remain silent against you in the forfeiture case.
That is staggering. The core right meant to protect you can actually hurt you when you're trying to get your house back.
Because the forfeiture is a civil case, the normal rules don't apply.
Yeah.
So you're in an impossible bind. Either you talk in the civil case to get your property back, which could expose you to criminal charges.
Or you stay silent to protect yourself criminally and risk the court inferring guilt and letting the government keep your property.
It just highlights the vast procedural chasm between civil and criminal law.
Let's transition back to that broader idea of due process and fairness, specifically looking at how laws have to be written. This is the void for vagueness doctrine. It's crucial because it ensures you can actually know when you're about to break the law.
Exactly. Due process requires that criminal laws be definite enough to give citizens fair warning of what's prohibited and to give law enforcement clear guidelines. If a law is too vague, it leads to arbitrary and discriminatory enforcement.
It effectively gives police or judges total discretion.
It does. And this might sound philosophical, but the results are very practical. Look at the famous Chicago gang ordinance case, City of Chicago v. Morales.
What was that about?
The Chicago ordinance let police order people to disperse if they were loitering with criminal street gang members and had no apparent purpose. The Supreme Court struck it down.
No apparent purpose. That was the sticking point.
That was the fatal flaw. It's completely subjective. What does that even mean? Are you waiting for a bus? Enjoying the evening air? The standard was so open-ended, it gave officers absolute, unfettered discretion to decide who to arrest.
So it ended up targeting a person's status being near a gang member rather than any clear conduct.
That's the line. A similar law that targets a specific intent like congregating with the intent to cause annoyance or alarm, that's usually upheld. It focuses on tangible, disruptive conduct.
Okay, now let's touch on equal protection. We all know the 14th Amendment applies that to the states, but how does it apply to the federal government?
The Fifth Amendment's Due Process Clause is understood to have an equal protection component baked into it. It means federal laws that create classifications based on sex or military status or whatever have to be reasonable.
Would need to be rationally related to a legitimate government goal.
Exactly. It prevents the federal government from discriminating arbitrarily.
Give us a real-world example of a classification the court said was reasonable.
Okay, so for a long time, federal veterans laws gave educational benefits only to those who had served on active duty. This excluded conscientious objectors who did alternative service.
And that was challenged as discriminatory.
It was, but the court upheld the law. It said Congress could reasonably conclude that the disruption and dangers of active military service were fundamentally different from alternative service. The benefits served the legitimate goal of making military service more attractive. So the classification, while it drew a line, was considered rational.
Now let's talk about the military itself. The Fifth Amendment has a huge exception right in the text for cases arising in the land or naval forces.
It's a profound exception. It's designed to maintain military discipline. It means military members can be tried by court-martial for any offense without a grand jury indictment.
So a core Fifth Amendment protection just doesn't apply.
It doesn't. And the Supreme Court has repeatedly said that its own review of military court proceedings is very narrow. It's mostly just to make sure the military court had jurisdiction.
But even that military power has limits, especially when it involves U.S. citizens. The case Hamdi v. Rumsfeld was a huge deal here.
It was a pivotal moment. The Supreme Court ruled that even a U.S. citizen, captured in a military conflict and labeled an enemy combatant, still gets minimal due process. You can't just hold a citizen indefinitely without some kind of legal process.
What were those minimums?
The court said they had to get notice of the factual basis for being held, a fair chance to rebut that evidence before a neutral decision-maker, and the opportunity to talk to a lawyer. It shows that the core of due process notice and a chance to be heard is irreducible, even in a national security context involving a citizen.
Finally, we have to revisit the rights of non-citizens, where your status and your physical location mean everything.
This is a difference with enormous practical consequences. For aliens who are seeking to get into the country, those at the threshold of initial entry, their rights are extremely limited.
Even if they're physically inside the U.S., like at an airport detention center?
Right. So the Supreme Court has said they generally only have whatever rights Congress decides to give them by statute. The government has broad constitutional power to deny entry without a full-blown hearing.
So if you haven't successfully entered, constitutional protections for that entry process are almost non-existent. But once you're in,
the equation changes completely. Aliens who have passed through our gates, even illegally, or who have developed substantial connections here, are generally entitled to full due process protections before they can be formally removed.
what does that entail?
Well, removal is a civil proceeding, not criminal. But the government has to present clear, unequivocal and convincing evidence. And the person is entitled to a hearing, a chance to present their own evidence, and the right to an attorney, though not necessarily one paid for by the government. The simple act of crossing the border triggers the full procedural requirements of the Fifth Amendment.
And that brings our deep dive to a close. We've covered the 4 foundational rights inside the Fifth Amendment. We've gone from the absolute finality of an acquittal, even one based on a judge's mistake, to the very strict rules around your right to silence.
Rules that hinge on legal labels like custody and whether you explicitly claim the privilege.
Exactly. And we've explored how the government can and cannot take private property, while also shining a light on the very challenging realities of civil asset forfeiture.
So what does this all mean for you, the listener? I think it means the procedural rules, the labels we put on a judge's decision, the location of an interrogation, the exact wording of a law. These are often the only walls protecting your substantive rights.
They're not just technicalities.
Not at all. The entire legal system relies on strict, almost pedantic adherence to these details to balance government power against individual liberty. And knowing where those boundaries are is just invaluable civic knowledge.
Absolutely. Understanding these lines lets you see when the government is operating within its bounds, or maybe when it's stepping outside them. And that leads us to our final provocative thought for you to chew on this week.
It connects the idea of compulsion and the right to silence. So, reflect on this. Public employees, like police officers, can be forced to answer job-related questions or lose their employment.
Provided that their compelled testimony can't be used against them criminally. It's known as the jeopardy rule.
Right. So if you're ever in that position, where's the line between a legal obligation you have as part of your job and your constitutional protection in your private life? The government is essentially forcing a choice between your livelihood and your silence. It neutralizes the constitutional protection with immunity, creating this profound test of the Fifth Amendment's real-world power.